Good morning, guys. Today we are going to discuss national security laws in India. This is one of the very important topics that we must discuss. Uh, First of all, before going to sort of understand and discuss various national security laws in India, let's try to uh, understand what is national security first, and then we'll move on to discuss various national security laws uh, of India. So, first of all, the larger question is, what is national security as such? We need to understand what is national security as such. We need to understand this concept first, and then we'll move to discuss various national security laws of India and why they were needed and why they were, sort of legislated by the government of India, what were the purposes, and so on. So, first of all, national security is basically is the protection of a nation's border, sovereignty and interest from external and internal threats. So it would, encompass economic, military, political, cyber security, etc. So the whole idea of national security is to sort of, safeguard the country's territorial integrity and ensure the well-being of its citizens. So we know that many nations are facing lots of security challenges, both internal and external. For instance, there are challenges of terrorism. There are challenges of espionage. Then you have cyber attacks. Then you have economic crises, non-state actors, pandemics, and so on. So all these are basically national security challenges for a sovereign nation. Therefore, I think we need to discuss national security law, because all nations need to have certain laws to check challenges to its very existence or its sovereignty or law and order. So for that purpose, for instance, government of India has legislated many laws. We'll discuss certain important laws in our lecture today. So the purpose of national security law is basically to provide a legal framework to prevent and address threat to national security. So it covers laws relating to terrorism, or say cyber crime, or internal disturbances like some of the non-state actors like the Naxals or Maoist activities, etc. These are all broadly considered as national security challenges, and there are many activities which are seditious, or in other words sedition, right? So the state needs to sort of make law to prevent and control such challenges from threatening the national security of a country, right? So this is basically about the national security laws that the government of India uh, makes over a period of time to check various challenges it faces over a period of time. And in this context, we would discuss many important acts of the government, or many important laws of the government, which are very important for the national security of India. Because after all, such national security laws or acts or active this acts are basically for protection of national sovereignty and also to maintain law and order. So the first thing that we'll be discussing in this particular brief lecture would be on UAPA, that is Unlawful Activities Prevention Act, or UAPA, right? And the goal of this particular activities is to give authorities to deal with such activities that actually threaten India's integrity and sovereignty. So for example, uh, you have some other you know special laws or extraordinary laws, national security laws. For example, Armed Forces Special Powers Act, AFSPA, is a highly contentious kind of law or a piece of law. We often see this in media. The other one is Prevention of Money Laundering Act. Then you have Information Technology Act of 2000, further amended in 2008. Then you have National Security Act in 1980. There are various acts, including Public Safety Act in 1978 in the context of Jammu and Kashmir. You have Foreigners Act of 1946, and then you have uh, you know various sedition laws, etc., and Official Secret Act 1923. So this lecture will be confining to some of the national security laws, not all, right? So let's begin with UAPA, Unlawful Activities Prevention Act 1967 is one of the very important piece of legislation or law. It is very important law because this is often invoked by the authorities in order to maintain law and order in India. In fact, if you look into the evolution of the UAPA, that is Unlawful Activities Prevention Act, a committee on national integration and regionalization was actually established by the National Integration Council to consider the issue of imposing reasonable limitations in order to protect India's interest, or in other words, sovereignty and integrity. So what is UAPA as such? The UAPA is basically in order to protect India's sovereignty and integrity. Constitution 16th Amendment Act was actually passed in 1963, right? So it was 16th Amendment Act 1963, which was passed by the Parliament, and it gave the Parliament the authority to set reasonable restrictions on the, for example, on freedom of speech and expression. So why this is very contentious? Because many people would say many things which may threaten India's interest or India's reputation, but reputation may not be one of the causes for using this particular provision, but it may create law and order problems. Uh, so freedom of speech and expression. Then you have right to assemble peacefully without arms, and the right to form associations or unions. That means these are some of the fundamental rights, and if necessary, the Parliament, according to 16th Amendment Act 1963, the Parliament has the authority to set reasonable restrictions on these freedoms and rights, even though they are fundamental rights. So therefore, this is very highly contentious piece of law, and government even frequently use this particular law called UAPA, or Unlawful Activities Prevention Act 1967. So imposing such special laws or national security laws are about curtailing freedom of certain individuals. So therefore it is very contentious. Many people move to the court saying that these laws are actually contrary to the fundamental rights guaranteed under Indian Constitution. So afterwards, the Unlawful Activities Prevention Act was, you know, uh, created. That is, UAPA was created in 1967. After this, this uh, 1967 was this Unlawful Activities Prevention Act was actually created in 1967 to prevent organizations in India from engaging in unlawful activities. So this is also referred to as the anti-terror law. So this particular law is also referred to as what? Anti-terror law, right? So this is very important to remember. However, in 2019, most recent amendment was made to this particular act, the Unlawful Activities Prevention Act, and the Unlawful Activities Prevention Amendment Act 2019, which now empowers the union government to designate certain individuals as a terrorist after following proper legal procedures. So so far as the background of the UAPA Act is concerned, in the middle of 1960s, as you are very familiar, and we have already discussed many of these arguments in our lecture, uh, that the union government was the union government was considering enacting strict legislation prohibiting demands for secession, etc., because India was going through lots of internal security challenges. So the first one is basically about prohibiting demands for secession, right? For uh, many you know uh, groups where separatists were actually demanding for autonomy. So this was a sort of national security challenge for India. Again, we also know that there were many peasants rebellion in India, and in this context, this particular law of 1966, for example, the government had to bring an ordinance, right? Uh, a peasant rebellion in Naxalbari in March 1967, right, created a sense of urgency, right, to deal with it. The president had to issued unlawful acts prevention ordinance in June 1966. So the act allowed for designation of an association or group of people as unlawful if they engaged in any activities that include actions, words, or statements that supported any or to bring about secession of a part of the territory of India, or its secession, or that questioned or denied the country's sovereignty and territorial integrity. So prior to UAPA's enactment, associations were being declared unlawful under the Criminal Law Amendment Act 1952, right? So the organizations were being in a sense declared unlawful under criminal law, right? Criminal law and Act of say 1952. So this particular law was there, which was being used by the authorities to declare certain association as unlawful. However, the Supreme Court ruled that the prohibitions clause was invalid since there was no judicial system in place to examine the legality of any restrictions, because you need to have a system in place, right? Who would enforce that? What should be the process of enforcement and so on? So as a result, this UAPA incorporated a provision for a tribunal that must confirm the notification declaring an outfit unlawful within 6 months. In its current form, the Act, following amendment in 2004 and 2013, includes provisions to prevent the use of funds for terrorist purposes, including money laundering, the declaration of association as unlawful, punishment for terrorist activities or acts threatening the nation's security, including its economic security, etc. So unlawful organizations were formerly prohibited for a period of say 2 years. However, in 2013, that timeline has been increased to 5 years. So it applies this particular law, UAPA Act, actually applies to both individuals and organizations. So in 2004, for example, amendment was carried out. A number of other organizations were also included, and it also included certain United Nations Security Council's anti-terrorism resolutions also. So this particular legislation included what? United Nations Security Council anti-terrorism resolutions. So the Act was further amended in 2019 to allow the government to designate an individual as a terrorist also, and it provided many important provisions. So what are the extent of the UAPA 1967? What are the extent of, say, this particular law, UAPA? This act actually extends to whole of India. Anyone in our country who violates this act's provisions and is found to be responsible is subject to punishment under this act. Any person who commits an offence outside of India that is punishable by this act would be treated in accordance with its provisions in the same way as if the offence had been committed within India, right? So the provision of this act applies also to citizens of India outside India, citizens of India outside India. Second, it also applies to persons in the service of the government, wherever they may be. The third one is persons on ship or aircraft registered in India, wherever they may be. This particular provision would apply on them. So declaration of an association as unlawful is one of the main features of UAPA. As per UAPA, for example, if the central government believes that a certain association is or has become an unlawful association, it may proclaim the association to be unlawful by publishing a notice in the gazette, official gazette. So each of these notification must state the grounds for their issuance. No such notification shall take effect until the tribunal has approved the declaration contained therein, except the central government may, for reasons to be stated in writing, declare an association to be unlawful with immediate effect if it believes that circumstances exist that make such declaration necessary, right? So central government uh, 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 may, by order in the official, gazetteer, uh, add an organization to this schedule, add also an organization to this schedule which is identified as a terrorist organization in a resolution adopted by the Security Council to combat, international terrorism. It can also remove an organization from this schedule and amend the, schedule in some other way. So uh, who can be called, to be involved in terrorism. An organization can be, involved in terrorism if it, for instance, commits or say participates in acts of terrorism, or say prepares for terrorism, or promotes or encourages terrorism, or is otherwise, involved in terrorism or terrorist activities. So terrorist organizations are actually listed in Schedule 1 of UAPA Act 1967. This Schedule 1 of the Act states that, in the opinion of the central government, if any association is unlawful, may be by notification in the official gazette declare such organization to be unlawful. So there are many organizations or associations which had been, put in this schedule 1 of UAPA Act 1967. There are many organizations which we cannot highlight here in this lecture, but to name some of them, for example, Khalistan Jindabad Force, then International Sikh Youth Federation, Lashkar-e-Toiba, then Jaish-e-Mohammed, and then Jammu Kashmir Islamic Front, United Liberation Front of Assam, that is ULFA, People's Liberation Army, United National, Liberation Front, then National Revolution Front of, say, Tripura, Student Islamic Movement of India. These sort of, there are many others which has been included in Schedule 1 of UAPA. So it says that because this is a very, extraordinary piece of law, right? It's a very extraordinary, law, because it can put anyone in bar or under detention without producing before a particular, say, court. So the provision of tribunal was, envisioned under this particular UAPA. So when a notification declares any association to be unlawful, the central government must within 30 days refer the notification to the tribunal for the purpose of, determining whether or not there is sufficient, justification to declare that particular association to be unlawful. So this is very important because a law must have, in a democratic country like India, must have some, balance, right? Some sort of balance. So the central government has the authority to appoint a single member, tribunal, as the unlawful activities prevention tribunal if and when required, right? So the appointment is done by the central government, provided that the person shall be a judge of a high court, and all expenses related to the tribunal shall be uh, spent out of the consolidated fund of India. In all matters, arising out of the performance of its duties, the tribunal shall have the authority to regulate its own procedure. So tribunal will have same authority to, conduct an investigation under this act that a civil court would have under civil, Code of Civil Procedure of 1908. So provision are also there related to seizure of cash if they declare certain individuals or organizations as, say, unlawful, then the investigating officer may seize or detain any case if he has reasonable grounds and are suspecting that it is intended to be used for the purpose of terrorism, or it forms the whole part of the resources of the terrorist organization, right? So uh, there are uh, merits and demerits of UAPA. We know we live in a democratic society. India is a democratic nation, and therefore uh, there are many criticisms against this particular provision, because this is a very powerful law, right? Uh, what are the First of all, let me tell you a bit about the uh, uh, what the uh, merits of UAPA, Unlawful Activities Prevention Act. What are the merits? The first merit is effective counter terrorism measures, because India is one of the largest country, and India has lots of diversity, geographical, ethnic diversity, and therefore it needs to have certain law which would actually counter secessionist activities, etc., or disruptive, or say uh, any activities that would challenge the sovereignty and integrity of the country. So the first merit, therefore, is what? Effective counter terrorism measure. If you have no law, then the authorities will become handicapped in sort of meeting, or sort of addressing uh, or checking such challenges to national security. So UAPA was therefore enacted to provide legal framework for combating what? Unlawful activities and associations that threaten India's sovereignty and integrity, right? The second thing is about banning. You need to ban certain organizations also if they are creating trouble for the national interest, for integrity of the nation, or for India's sovereignty. So banning is necessary, right? So government can ban any organization which is unlawful in nature, uh, right? The third thing is about addressing terror financing, because no such activities can be carried out without involvement of finance, like administration. The terrorist activities also need financial resources. So UAPA includes clauses that criminalize the financing of terrorism, enabling authority to trace, block financial channels supporting terrorist activities, etc., in India. So these are some of the very important merits of UAPA for law and order, for say to address the questions of secessionist activities or terrorist activities, etc. What are the demerits? Because we live in a democratic society, and there are many people who challenge such laws because they you know encroach upon our freedoms and rights. So there is also a possibility that such powerful law can be used against uh, others for political interest. So what are the demerits? The authorities are not able to actually uh, charge you know uh, such individuals or organizations for a long time. They cannot even file complete their investigation, right? So prolonged detention without formal charges is not a good thing. It should be quick. It should you know be completed within a reasonable time. So legal provision section, for example 43D clause 2 of UAPA, 43D clause 2 of UAPA permits detention of individuals for up to say 180 days without filing a charge sheet also. So it is dangerous for individuals. Suppose if there is a person who is innocent and he's put behind bar for 180 days without filing a charge sheet also. So uh, it can also extend beyond standard 90 days under the general law of this country. So this extended detention period has been criticized for violating personal liberty and the right to a speedy trial, because it is the rights of all individual, all citizens in India to have what, a speedy trial, speedy and fair trial. The second thing, demerits, is that there is no provision of easy bails and all, because there are stringent conditions. There are stringent bail conditions. There are legal hurdles. There are for example, section 43d5 imposes stringent condition for granting bail, making it challenging for the accused to secure release during the trial period. So the implication is this often leads to prolonged incarceration of, or say prolonged detention without conviction, raising concerns about human rights violations. The third demerits is lack of judicial oversight, because there is no judicial oversight over the particular such extraordinary laws. Some others are also there, we'll discuss in a while briefly. So lack of judicial oversight. The act grants significant power to the law enforcement agencies without or with limited say judicial scrutiny or oversight. So it increases the potential of, or potential for say misuse of this particular law, that is UAPA. So this can lead to arbitrary arrest. This can lead to detention without sufficient evidence, etc. So this is one of the very important some of the important demerits of the UAPA. But above all, as we know that the misuses of UAPA can be very serious for a democratic society like India. For example, misuse means what? For personal political interest, this particular provision can be used. For example, targeting activities, activities of say civil liberty, uh, movements, or targeting activists or journalists, etc. This will create a serious problem for a society like ours. So targeted use of UAPA can be a serious problem. Low conviction rate is another very serious concern with regard to UAPA. Why? There is a low conviction rate in UAPA. The prosecution is not able to prove that such individuals were actually involved in any activities which were anti-national or seditious in nature. The third thing is that judicial observations on misuse is also a alarming call that we need to address, right? So targeting what? Targeting activities or activists and journalists, low conviction rate, judicial observation of misuse. So judiciary says that for example in June 2021 the Delhi High Court observed that the state had been applying UAPA provisions to to cases that didn't fall under the ambit of terrorist activity, thereby broadening the scopes of of that particular law unjustifiably. So Supreme Court also remarked in one of the cases, and it cautioned against the misuse of UAPA and there is a it said that there is it needs for its application strictly in cases involving genuine threats to national security, right? So these are some of the merits, demerits, and the possibilities of misuse of UAPA, etc. The next very important provision of important one of the important laws is National Security Act 1980. What is the background? What was the purpose of having this particular law? This National Security Act of 1980 uh, was basically relating to, say, preventive detention law, right? Uh, so NSA, National Security Act 1980, the NSA is a preventive detention law enacted in 1980 to maintain what? Public order and national security. So preventive detention involves the detainment or containment of person in order to keep him or her from committing future crimes, right? From escaping future prosecution. So for example, when we say this particular preventive detention, article 22 article 22 3b of the constitution allows for preventive detention, because the constitution had to be amended, because many protested that the person cannot be arrested under the law called this preventive detention. So it had to be, there is no such law. So because in all individuals had fundamental rights, and and therefore the government had to uh, pass a law in order to empower the enforcement authorities to stop uh, persons or to detain person uh, in order to maintain public order and national security, etc. So article 22 3b of the constitution today allows for preventive detention and restriction on personal liberty for reasons of state security and public order, right? So allows for what? This particular law, that is National Security Act 1980, allows for what? Detention to prevent disruptive actions. If there is a possibility, if the authority believes that there is a possibility of a particular person creating any problem for the security of the state and public order, in that case he can be arrested and put under this provision called preventive detention. So article 22(4), for example, article 22(4) states that no law providing for preventive detention shall authorize detention of a person for a longer period than 3 months, right? So a person cannot be detained for more than 3 months. So what this particular law gives, what power this particular law gives to the government? The NSA, that is National Security uh, uh, Act, National Security Act, empowers the central or the state government to detain a person to prevent him from acting in any manner prejudicial to, say, national security. So the government can also detain a person to prevent him from disturbing public order, or for maintenance of supplies and services essential to the community. So what is the period for confinement or detention of such persons? The maximum period for which one may be detained is 12 months. So the establishment of National Security Council, uh, uh, you know, uh, became a reality. So this act actually, provided for the constitution of a National Security Council, which advises the Prime Minister on matters relating to national security. So National Security, Council in India is highly, is a very high level body that advises the Prime Minister of India on matters related to national security, strategic policy, and defense, etc. So it is a three-tiered organization that oversees what political, economic, energy, security issues of, say, strategic concerns, and NSC, that is National Security Council, is actually chaired by the Prime Minister. It was formed in 1998, where all aspects of national security are actually deliberated upon. So who can be member, or who are the members of the National Security Council? So National Security Advisor, you might have heard about National Security Advisor, right? National Security Advisor, then you have Chief of Defense Staff, then you have Deputy National Security Advisor, or say Ministers of Defense, External Affairs, Home or Finance, including the Vice Chairman of the Niti Aayog. So what are the functions of this particular uh, NSC, that is National Security Council? It advises the Prime Minister on issues of national security, strategic policy, and defense, providing strategic direction to the country's security and defense policies, and ensuring their implementation. It also conducts regular reviews of the country's security situation and makes recommendation to the Prime Minister on policy changes if needed. It also coordinates activities of various agencies. It analyzes emerging security threats and provides early warning to the government, and preparing contingency plans for various security scenarios, etc. But this act is also often criticized. Uh, One of the major challenges of, say, National Security Act is its potential misuse by the authorities. Right, the law grants the government the power to detain individual without trial for up to a year. So this is a very, very powerful piece of law. This power can be easily misused by the authorities. It may lead to violation of human rights, right? Or it may lead to violation of right to a fair trial, the right to freedom of expression, right to personal liberty, etc. It also lacks, transparency. This is a major challenge uh, that NSA is the lack of, lack of transparency is a major challenge with the National Security Act. Uh, because lack of transparency in the detention process is a major challenge. Uh, why? Detainees are not often informed of the ground for their detention, and the detention orders are not made public also. This lack of transparency often create chaos, social chaos, and allegation against the government that this particular provision is being misused by the authorities. Then there are legal challenges also. uh, for example, critics have argued that the law is unconstitutional and violates fundamental rights guaranteed under Indian Constitution, right? So Supreme Court of India also has also struck down several detention orders issued by the national security under this National Security Act. So it has limited effectiveness, therefore, right? While the NSA is intended to prevent threats to national security, its effectiveness is very, very limited. Detaining individual without trial may not necessarily prevent the threat, etc., right? in some of the cases. It may not exacerbate the problem by radicalizing individuals, etc. So what are the way forward then in the context of National Security Act? It should ensure transparency first. It should ensure what? Transparency, because it is not transparent. Transparency is very, very important, right? Transparency is very, very important. There is a need for a strict implementation. The third thing is there is a need to strengthen judicial oversight also, and there is a need to focus on intelligence gathering. The government should focus on intelligence gathering and other measures that can help prevent threats to national security without resorting to, say, for example, frequent use of preventive detention, right? So this is about NSA. The third one is basically about uh, AFSA. This is a very important piece of legislation, and it was in news also very recently. Therefore, we need to let's understand the this particular law, what it is, what is AFSA, what is the background, right, and why it is criticized, or what are the merits or demerits, etc. We are not going into the entire history of the AFSA, otherwise it will be hard for me to cover the entire laws, some of the important laws at least. So see, for example, this particular law, if you look into the historical context, the British colonial government had on 15th August 1942 actually promulgated the Armed Forces Special Power Ordinance to suppress Quit India movement. It was the foundation for four ordinances, including one of the Assam disturbed area invoked in 1947 to deal with partisan induced internal security sort of challenges. Then the Armed Forces Assam Manipur Special Power Act 1958 followed the Assam Disturbed Areas Act of 1955 to deal with uprising in the Naga Hills and adjoining areas. The act also replaced by the AFSA for wider application. A similar act specific to Jammu and Kashmir was also enacted in 1990. So what Armed Forces Special Act bill was passed by both the houses of parliament, and it was approved by the president on September 11 1958. So in September 11 1958, it you know it was approved by the president. So it became known as Armed Forces Special Powers Act, or AFSA, right? AFSPA, AFSA 1958. So the act came into force in the context of increasing violence in northeastern states decades ago, which the state governments found it difficult to actually control. So AFSA actually gives on breached uh, power to the armed forces, right? So it gives very much power to the armed forces and the central police forces deployed in such disturbed areas, as specified under this particular act, to kill anyone acting in contravention of the law, or arrest or search any uh, premises without a warrant, and ensure protection from prosecution and legal suit without the central government sanction. So this is a very, very powerful law, because the armed forces can actually use power, can arrest, can search, you know and also if necessary can kill anyone if acting in contravention of the law. So this is a very, very powerful law. I mean, this is a enormous power AFSA gives to the armed forces. So therefore, the state government can issue notification regarding AFSA also uh, for states of say Arunachal Pradesh, Nagaland, that is Ministry of Home Affairs issues periodic list of say disturbed areas notification. Uh, so AFSA actually this AFSA actually talks about disturbed areas. So it says there is something called disturbed areas where this particular law applies. So what is this disturbed area? A disturbed area is one that is declared by notification under section 3 of AFSA, right? AFSA section 3 uh, of Armed Forces Special Act uh, actually defines what a disturbed area is as such. So it can be invoked in any places where use of armed forces in aid of civil power is necessary. So the act was amended in 1972, and the power to declare an area disturbed were actually conferred concurrently upon the central government along with the states. So because there was a country, there's a uh, you know criticism against the central government that the state governments have no power whatsoever in this regard, and they should have a say in declaring at least which are the disturbed areas as such. So an area can be disturbed area due to differences or disputes between say members of different religious or racial or language or say regional groups or caste or communities. So the central government or the government or the governor of the state or administrator of the union territories can actually declare the whole or part of state or union territory as a disturbed area, right? So what are the argument in favor of this particular law, AFSPA? Argument in favor of uh, this particular law AFSPA is this: first, addressing ongoing security challenges, right? So it can actually address what some of the security challenges that these areas are actually uh, you know suffering. So this is first. It also can empower the security forces, if security forces, because such in disturbed areas the security powers, security forces needs to have certain amount of power, otherwise they cannot function also, right? So this second, there should also be a legal protection for personnel, because in discharging their duties they do many things. They cannot be brought uh, prosecuted for discharging their responsibilities. So legal protection for personnel, it provides what legal protection for the for personnel. It actually boosts morale to work in such disturbed areas. uh, but there are many arguments against the particular law of SPA. Why? The first thing is it violates the state's autonomy, right? So the states are very critical about it. The second criticism is the excessive use of force, right? Excessive use of force. And the third one is violation of civil liberties. What? Violation of civil liberties. And the next one is about lack of accountability. You do many things, but there is no accountability at all. And there are also evidence of certain which were brought before the court also, that there are certain evidence of abuses of the power, right? That the authorities or enforcement agencies use under this particular law. So the Supreme Court had to provide a guidelines, right? For example, question regarding the constitutionality of AFSPA arose due to its intersection with the jurisdiction of the state over law and order matters, because law and order is a state subject. So Supreme Court in 1998, in its ruling in Nagaland's People's Movement of Human Rights versus say Union of India, affirmed the constitutionality of AFSPA, right? So it said that it is constitutional. So in this landmark judgment, the court reached specific conclusion, including it said first, the central government has the authority to make a suo motu declaration, yet it is preferable for the central government to consult with the state government before issuing such a declaration. The next thing is AFSA doesn't grant unrestricted authority to designate an area as a disturbed area, right? Then the declaration must have a defined time frame, and there should be a regular assessment of its status also. After 6 months have passed, a review of the declaration is necessary. This is what Supreme Court had to say. Then when implementation of power is granted by when implementing the powers granted by the ASPA, the authority or authorized officers should employ the least amount of force required for successful operations, right? So there are do's and don't for do's and don't for the enforcement agencies prescribed by the Supreme Court of India. The recommendation of the Sanjeevan Reddy Committee, right? Because it was a very contentious piece of legislation. It was brought before the court. It was highly politicized, and it was criticized by many intellectual civil liberty movement, etc., that this law is very powerful and actually violating the freedoms and rights of individuals who live in such disturbed areas. So the government had to set up certain committees also. For example, there was a committee called Jivan Reddy Committee. In November 2004, the central government appointed a 5-member committee headed by Justice P.B. Jivan Reddy to review the provisions of the Act in the northeastern states. And the committee actually recommended that AFSPA should be repealed and appropriate provisions should be inserted in the Unlawful Activities Prevention Act 1967. Instead of having AFSPA, we can empower the existing law like this Unlawful Activities Prevention Act, UAPA. That would be sufficient. So Unlawful Activities Act should be modified to clearly specify the power of the armed forces and paramilitary forces, and grievance cells should be set up in each districts where the armed forces are actually deployed. Then you had second ARC, Administrative Reforms Commission. It also recommended what it recommended. The 5th report of the second Administrative Reforms Commission on public order has also recommended the repeal of AFSPA. However, these recommendations were not being implemented by the government. Then you had Santosh Hegde Commission about this particular law AFSPA. So it said that AFSPA should be reviewed every 6 months to assess the necessity of its implementation, with the aim of making Act more humane and the security forces more accountable. So the committee suggested that Unlawful Activities Prevention Act should be suitably amended to tackle terrorism instead of relying solely on AFSPA. So these are some of the issues which comes under the national security what law. Uh, then you have Public Safety Act, right? You have Public Safety Act of 1978. Jammu and Kashmir is a preventive detention law again, under which a person is taken into what custody to prevent him or her from acting in any manner that is prejudicial to the security of the state or maintenance of the public order, right? So it is similar to National Security Act, and uh, uh, this is a very contentious piece of law in Jammu and Kashmir. So detention without trial then uh, is a very contentious kind of issue. Then there is also limited what legal remedies in this particular context, in this particular law. No right to file bail application also. This is a highly powerful piece of law. This Public Safety Act 1978 is very powerful. So only the High Court and Supreme Court have the power to hear have the jurisdiction to hear such petitions. So every individual cannot move the High Court and Supreme Court with their grievance. So it had also discretionary power, right? So it was another very very powerful law, and the Supreme Court once said on the context of Public Safety Act that while detaining a person under PSA, that is Public Safety Act, uh, the DM has the legal obligation to analyze all the circumstances before depriving that person of his or her personal liberty, right? Because it's a powerful piece of law. Then we have, for example, what the merits of this particular Public Safety Act of 1978. It is basically preventive measure to address separatist and militant activities. It helps in curbing threat to public safety and what sort of uh, public uh, uh, you know order, public safety and order. What were the demerits? Detention without trial. It actually violates fundamental rights. Then there is also weak judicial oversight, like and also there is limited transparency. So there are possibilities of also misuse. Detention of political opponent and dissenting voices may happen, and lack of clarity on criteria for public safety threats, etc., is another very very contentious issue. Another piece of law is about prevention of, this also related to what national security laws of India. So Prevention of Money Laundering Act of 2002, right? So it is about, what is this Money Laundering Act? This Money Laundering Act is about concealing the origin of illegally obtained money to make it appear legitimate, right? For example, there are at least three stages of money laundering. First is placement. Placement means introducing. There are three stages of what money laundering. First is placement, right? The second one is layering, and the third one is integration. And the third one is integration. Placement, layering, and integration. So when I say placement, it is about introducing illicit fund into the financial system, right? And when I say layering, complex financial transactions to obscure the money's origin, right? Transferring funds across borders, etc. Then comes integration. reintroducing this laundered funds as legitimate, investing in say real estate or business, etc. So people can use various means to for money laundering activities, structuring for example trade based laundering, then sell companies, real estate, etc., where you know this money laundering activities and money are invested through money laundering, etc. So what was the purpose of having this particular law, PMLA 2002? The purpose of having this PMLA 2002 is basically uh, the purpose of having this particular law PMLA 2002 is this: first, to prevent money laundering and confiscate proceeds from criminal activities. First, the second one is combat financial crimes like drug trafficking, terrorism financing or terror financing, etc. Right? So it came into force in 2005. This particular law, PMLA, actually came into force in 2005 following its enactment in 2002, and established in response to United Nations regulation also, right? So this is very important piece of legislation. What are the key provisions of PMLA? What are the key provisions of this uh, particular law? Offences and penalties: rigorous imprisonment of 3 to 7 years and fines for offenders. Enhanced penalty for specific crimes like drug related laundering, etc. Then attachment and confiscation. The property derived from laundering can be seized. Establishment of an adjudicating authority to oversee confiscation, etc. Right? Then reporting requirements are, for example, mandate banks, financial institutions, intermediaries to report suspicious transaction to financial intelligence unit, right? So these institutions are uh, uh, you know are bound under this particular law to inform the financial intelligence unit if there is anything suspicious, if there is any suspicious sort of transaction. But where to appeal in case somebody is caught under this particular law? So it provides for a mechanism for appealing adjudicating authorities decision, etc. So the objectives are therefore PMLA's objectives are therefore what: prevention, detection, confiscation, then international cooperation, etc. And there are also certain amendments to PMLA because often many new challenges actually are born, so the government actually what uh, can make some sort of amendments over a period of time. So uh, amendments were actually brought in by the passed by the government to expand the scope. For example, includes property derived from any criminal activities, not just listed offenses, right? So redefined, actually it redefined the they amended to redefine the crime, etc. Treats money laundering as say a standalone crime rather than being contingent on predicate offenses. Then greater focus on confiscation proceeds of crime and streamlining the investigation, etc. So why it is necessary for the adoption of PMLA? Why the government had to adopt? Because there is a big challenge globally, that is global drug trade, right? So narcotic trafficking, etc., illicit narcotic trafficking, was one of the main sources of money laundering. Uh, so in fact, Narasimha committee recommended that there is a need to address money laundering in India's banking reforms also, right? But there are many concerns with regard to uh, what PMLA. There is a problem with the definition. There is a definition is very vague, and it can be used against the political opposition, right? So it is criticized for what encompassing powerful transactions or lawful transactions, increasing potential misuse. So inclusion of non-drug offenses, then burden of proof of that is shift burden to the accused, conflicting with the principle of innocent until proven guilty provision doesn't apply if this happens or in this particular sort of law. So these are some of the concerns. There are also very stringent bail conditions under section 45 of this particular law, making bail nearly impossible for a person if they are actually arrested under these particular provisions. Then there are also certain protocols to arrest a person, but this provision would actually violate arrest protocols also. Arrest often occur without written communication and breaching constitutional rights under Article 22 of India's constitution. So there is a possibility of misuse also. It can be used as a political tool. Enforcement directorates alleged overreach is one of the allegation. The investigative procedure often they lack transparency, and also there is also an argument that they will impact on business because this is a very powerful law. So freezing assets based on suspicion disrupt what certain legitimate businesses also. So what are the some of the suggestions people actually make with regard to uh, PMLA? So uh, there is a problem with the definition, and uh, there is a need for introduce oversight mechanism for ED investigations, ensure fair trial without compromising with the fundamental rights, align with the general criminal laws to prevent undue hardship, then regularly update provisions to reflect involving financial crimes, etc. So publish annual reports or enforcement actions and outcomes, etc. And there is a need also to educate citizens about their rights and the acts, this PMLA scope, right? Why this particular law is highly criticized? The conviction rate in this particular law is only 2 to 5%, indicating prolonged trials, etc., right? uh, for example, ED claims seizure worth over 1 lakh crore under PMLA as on say 2022. uh, Nearly there are 5,500 cases since its inception, with over 1,400 ongoing investigations, and also uh, there are also problems with regard to complex prolonged procedures for accused individuals. There is a scope for misuse because of the vague definitions. It may also be used to harass political opponents or its critic. Also, it may be used to target businesses or individual without substantial evidence, etc. So these are some of the what uh, uh, provisions with regard to PMLA. Another law is Foreigners Act law of 1946. I'll talk a bit about it and then I'll stop. Foreigners Act 1946, 46 was uh, you know amended many times, and it has a long history also, right? It has a long history uh, as to how, for example, uh, the government can actually what make rules with regard to persons entering India to be in India illegally, or say uh, uh, if persons, for example, are arrested, detained because of lack of, say, what uh, legitimate documents. So the foreigners, this particular law, this Foreigners Act, therefore talks about what, dealing with foreigners, that provided for the expulsion of foreigners, right? It also allowed arrest, detention, and for a ban on foreigners entry into India, after detention, etc. So, therefore, government had to introduce passport. So, it is Passport Act 1920, right? Uh, the act actually empowered the government to make rules requiring persons entering India to be in possession of passports, right? It also granted the government the power to remove from India any persons who enter without a passport. So the concept of burden of proof actually lies with the person and not with the authorities. So, Foreigners Act 1940, for example, it was enacted during the Second World War, under the under which the concept of burden of proof was introduced, and this meant that whenever a question arose with regard to the nationality of a person, the onus of proving that he was not a foreigner actually lay upon the person concerned. So, therefore, Foreigners Act 1946 came. It replaced the Foreigners Act 1940 and 1946, right? This 1946 Act actually came. Foreigners Act 1946 actually replaced Foreigners Act 1940, conferring wide power to deal with all foreigners. So the act empowered the government to take such steps as necessary, or as are necessary, to prevent what, illegal migrants, including the use of force, right? So the act empowered the central government to establish tribunal which would have the power similar to those of a civil court. So what are the merits of this particular piece of law, that is this 1946 Foreigners Act 1946, essential for regulating entry and deportation of foreigners. So this is very important, right? There is a need for uh, what, essential for what, deportation, right? Regulating entry and deportation of foreigners. It also helps in maintaining border and internal security. The demerit is this, that outdated provisions for modern border management challenges, right? So we have newer set of challenges. So there is a need to update certain provisions of this particular Foreigners Act 1946. Uh, Discretionary powers leading to inconsistent enforcement. There are certain discretionary powers with the authorities concerned. There is a misuse also, targeting refugees, and also, for example, undocumented migrants unfairly is a misuse. Selective application in politically sensitive cases is also what, misuse of the what, of this particular law. Another law is basically Information Technology Act 2000, amended in 2008. What is the merit of this act? It protects against cyber crimes and digital frauds. It facilitates secure digital transaction and communications, etc. But the demerits of this particular law is this. For example, broad provisions under cybercrime can be actually misused or misinterpreted also. Uh, it lacks, for example, lack of user awareness about the data privacy regulations, etc. So the third thing is that there is a arbitrary blocking of websites or platform targeting activities for digital dissent, etc. also is brought before all of us, and we have seen this. So this is another piece of law for maintaining you know uh, security and internal security and order uh, in our society, in our country. The third law, which was repealed, was a very powerful piece of law that is known as uh, what POTA, of prevention of what uh, I think I have not included in this particular law, that is POTA, right? POTA is another 2002 is another very important piece of law which was actually repealed by the government of India because of many criticisms and also their allegations of misuse of this particular uh, act. So Prevention of Terrorism Act 2002, also known as POTA, was repealed because it was a very powerful law. What were the demerits? It addressed terrorism comprehensively during its enactment, right? It enabled swift prosecution of terror-related offences. But what was the demerit, and for what reasons this was actually uh, repealed? This particular law was repealed. So the demerit is there was a widespread criticism for human rights violations, and the secondly, uh, it replaced due to allegations of the misuse and overreach. And the message is this, that detaining individual for political reasons, misbehaving, or say mislabeling for particularly civil activist as terrorist or some intellectual as terrorist, etc. Then comes Official Secret Act of 1923. It protects sensitive national security informations, right? It provides provision for what? Protection of sensitive national security information, right? So it is related to protection of sensitive national security informations and prevents spionage and sabotage, etc. But it is outdated for modern security challenges like cybercrime. There are also ambiguity in defining secret documents, etc. And particularly after the introduction of Right to Information Act. Uh, so it was also misused to target whistleblowers or journalists, hinders transparency in governance, etc. So this was a colonial law. So this was another national security law, outdated sort of national security law, so to say. Then you have Defense of India Act, another law, uh, and this is very important piece of law, critical during emergencies, especially wartime. It provides a robust framework for say national defense measures, but it is also subject to temporary misuse during emergencies to suppress dissent, etc. So there are many other laws. For example, Explosive Act 1984, 1884, then Explosive Substance Act of 1908, etc., which Indian Penal Code, 1860. There are specific sections also. For example, Section 121, 124A, 153A address national security comprehensively, and ensures, for example, legal action against anti-national activities, right? So there are cyber security, laws also of different kinds. So these are some of the laws which I think uh, we need to discuss while discussing the question of national security in Indian context, right? So, for example, there are laws you might have heard about, seditious activities, etc. So, it's not a special. I mean, there are specific sections within Indian Penal Code of 1860, right, under IPC 1960. So, sedition laws are often viewed as, for example, we view as something colonial, and the government also made a announcement inside the floor of the house that sedition is basically colonial law, which does not actually address the present day reality, and said its willingness to actually scrap that particular law on sedition, right? So I stop here. uh, if you have any queries or any questions, you can connect with me. I prepared this lecture for all of you because many students were approaching me as to what are some of the important national security laws, and which we have to sort of study as such. So I stop here. You can connect with me. Thank you.